warm welcome everyone to this evening. Can I begin by acknowledging the traditional owners of the land on which we meet tonight, the Whadjuk people of the Noongar Nation, and paying my respects and our thanks to their elders past, present and emerging. And I think the choir was absolutely wonderful, so I also acknowledge how fantastic they were, in a perfect way to commence this year's Centre for Human Rights Education annual lecture. Established 2 years ago, this lecture is a key initiative of the Centre. As Baden has already indicated, in 2016 the inaugural lecture was delivered by Professor Gillian Triggs, former President of the Australian Human Rights Commission, and last year we had Dr Waleed Ali, writer, academic and award-winning broadcaster, as our guest speaker. So this year we're greatly honoured to welcome the Honourable Michael Kirby AC CMG to Curtin, the patron of the Centre for Human Rights Education, to deliver the 2018 annual lecture titled Where To Now? The Future of LGBTIQ+ Human Rights. And it's wonderful to see so many of you here this evening so obviously interested in the state of human rights. This annual lecture was established to encourage a strong human rights culture both within and outside of our universities. Universities have a key role to play in ensuring that we deliver on the vision of an Australia where human rights are fully realised and enjoyed by all. Because how we ultimately change the future of our communities and our nations is not only by giving equal access to education and opportunities for all, but by building a deep understanding of the fundamental importance of human rights. And this is a shared responsibility. As I've quoted previously, this sentiment was beautifully captured by Eleanor Roosevelt at the United Nations back on March the 27th, 1958, and I quote, "Where after all do universal human rights begin? In small places, close to home. So close and so small that they cannot be seen on any map of the world. Such are the places where every man, woman and child seeks equal justice, equal opportunity, equal dignity, without discrimination." We've seen recent examples in the media where the role of universities has been under the spotlight. But what we need to do is to ensure that as critically important public institutions, we don't shy away from staying true to our values. The tone for human rights is set by us all, and it must pervade all that we do and all that we are seen to stand for. To take a specific example, we must ensure that all of our policies and practices are inclusive of LGBTIQ+ people. We also have a responsibility to equip our staff and our students with the knowledge and tools that they need to embrace and celebrate the skills and unique perspectives of LGBTIQ+ people. This year we've had 160 staff and students complete the Curtin Allied training, and we've produced guidelines for transitioning at Curtin, the first university to do so. And Curtin has been recognised as a leading employer for LGBTIQ+ inclusion by the Australian Workplace Equality Index, receiving silver recognition for the past 2 years. Our reputation in this area ultimately comes down to the views and commitments of our people and to our ally network, established in 2006 to provide support and understanding to Curtin's LGBTI community. During last year's politicised plebiscite, our staff's support for LGBTIQ+ staff and students was outstanding, and something that made me feel deeply proud of Curtin, going to the absolute core of our values as a university. The theme of this year's lecture, Where To Now? The Future of LGBTIQ+ Human Rights, clearly pivots our focus to the future after the prolonged attainment of marriage equality. It is a topic that our guest speaker tonight, the Honourable Michael Kirby AC CMG, is well qualified to deliver. Michael was Australia's longest serving judge from 1996 to 2009. He retired from the bench after 34 years, with 13 years on the High Court of Australia. He served on 3 university governing bodies and was Chancellor of Macquarie University from 1984 to 1993. He's been involved with many national and international bodies, including the World Health Organisation's Global Commission on AIDS, the High Commissioner for Human Rights Judicial Reference Group, and the UNAIDS Reference Group on HIV and Human Rights. As a judge, he wrote clearly and fearlessly, frequently in the minority and always with an eye to the future. He was the inaugural president of the Australian Law Reform Commission, and reports published by the Commission are regarded even today as the gold standard of law reform. As a writer, he's unmatched by any Australian jurist, having published hundreds of articles and numerous books. In 1990, he was awarded the Australian Human Rights Medal, and in 1998 he was named Laureate of the UNESCO Prize for Human Rights Education. His tireless work to remove discrimination against lesbian, gay, bisexual and transgender communities is well known and highly regarded. The editors of a large tome dedicated to Michael's work in 2009 said, and I quote, "None of us can be all things to all men, but a select few can set an example that inspires the rest of us. Michael Kirby is such a man." In 2017, he was awarded an Honorary Doctor of Letters by Curtin University in recognition of his outstanding record and his promotion of human rights in Australia and overseas. So please join me in recognising. The Honourable Michael Kirby. Thank you.
Professor Deborah Terry, Professor Baden Offord, Professor of Human Rights, Professor Paul Farrell, the Dean of Law, and ladies and gentlemen, fellow citizens. I also honour the Indigenous people of our country. From one side of our continent to the other. I will be crossing over the continent tonight on my way back to Sydney on the Midnight Express. But I'm thrilled to have been here for that magnificent performance by the Gay and Lesbian Choir, which has invigorated us and which will inspire these words that I will now utter on the future directions and the future obligations of all of us in the human rights of LGBTIQ people in this country and beyond. On the 15th of November 2015, results of a postal survey were announced, which quite exceptionally had been interposed between a proposal that marriage law in Australia should be amended so as to permit same-sex couples to be married, and that survey resulted in a vote which was approximately 60-40 in favour of the proposed change. In December 2017, within a month of that survey, the Federal Parliament in Canberra enacted the amendment to the Marriage Act 1961 to so provide. Many said that this was a silver lining in what was an exceptional and prejudicial survey as a precondition to the change, quite unusual in Australia, with no precedent for 100 years. But the change was made, and the issue for us tonight is what still lies ahead. The title to the statute that provided for marriage of same-sex couples in Australia was somewhat ominous for LGBTIQ citizens. It rejected an aspirational title of marriage equality, which had been used in the third ACT law, which had been invalidated by the High Court of Australia in December 2013 with a decision that said that such a law could only be enacted by the Federal Parliament. For many opponents, there was no equality in the married relationship effected between same-sex parties by the amendments to the Marriage Act. Those relationships were seen as different and dubious. That was their reason for insisting that the Old English word marriage did not properly fit those relationships. The Reforming Act, enacted after the Postal Survey result, was titled Marriage, in brackets, Definition and Religious Freedoms, close brackets, Act 2017 of the Commonwealth of Australia. For opponents, the use of the word marriage was no more than a sleight of hand and a lawyer's use of a definitional trick. It could not change the substance. Doubtless that is why the title was propounded, to make the statute tolerable for the members of Parliament who still basically objected to the whole idea. Nonetheless, the religious opponents of marriage equality didn't win all the battles in 2017. The Marriage Act, as amended by the 2017 Act, would redefine marriage as a union of two people. A new category of religious marriage celebrants was added so that they, together with ministers of religion, chaplains and bodies established for religious purposes, could refuse to solemnise or provide facilities, goods or services for marriages on their religious grounds in defined circumstances. The anti-discrimination laws were to be reduced in their ambit to allow for that discrimination. In 1993, the United States Congress had likewise enacted the Religious Freedom Restoration Act. It was adopted by a unanimous vote of the House of Representatives of the United States, and only 3 senators in the Senate of the United States voted against it. However, in 1997, the Supreme Court of the United States held that the law was unconstitutional insofar as it purported to apply to the states. Still, it has continued to apply in federal jurisdiction, the Religious Freedom Restoration Act. Powerful opponents of same-sex marriage in the Federal Parliament of Australia called for the enactment of new federal laws and the amendment of present laws to counter what they described as the creeping encroachment from the state on religious beliefs and the use of political correctness to marginalise and silence the religious perspective, and also to respond to a supposed modern problem arising where religious freedom rubs against laws written to protect other rights. This call has been accompanied by very substantial increases in promised federal subventions to private and religious schools, which go far beyond those earlier endorsed by the Turnbull government. The additions go on top of earlier very large subventions allowed by the Federal Parliament to support the facility of chaplaincy programs, providing religious chaplains for public schools, although those schools had been established throughout Australia in the 19th century as a great national experiment in the provision of general education that was free, secular and compulsory. Mr. Morrison's insistence in his first major address as the Prime Minister of Australia of his love for all Australians is no doubt to be welcomed. However, necessarily, all Australians includes LGBTIQ Australians. Many of them probably feel anxiety about the ambit of the expressed political love. They will do so because of the fact that in the marriage survey, every one of the Christian denominations, except the Quakers and some sections of the Uniting Church, took a strong institutional stand hostile to the extension of marriage to LGBTIQ citizens. The anxiety will not have been diminished by the reported statements attributed to Mr. Morrison in an early radio interview as Prime Minister that the Victorian schools program about teen sexuality made his, quote, skin curl. That instruction on building respectful relationships was simply a fancy word for safe schools. That public schools should be, quote, focused on things like teaching maths and science, end quote, and inferentially that they should not teach the values of respecting diversity in sexual orientation and gender identity. Now, Prime Minister Morrison is himself an alumnus of a most famous public school in Sydney, Sydney Boys High School. Inferentially, that school taught our Prime Minister values that he reflects in his life, as did the values that I received just 10 kilometres away in another great public school in Sydney, Fort Street High School. Whilst not supporting the discredited procedure of gay conversion therapy, our Prime Minister, in answer to media questions, refused to condemn that procedure, stating that, quote, he had never really thought about it, end quote. In fairness, he said that he, quote, respected people of all sexualities, end quote. The Prime Minister's choice of a Baptist religious private school for his daughters is, of course, a matter for him and his wife, doubtless in discussion with his daughters. However, there appear to be resonances in his reported statements, resonances of the old approach to sexual orientation and gender identity in Australia. That approach, at least during the time that I was growing up, knew scientifically that there were LGBTIQ people, including children, in our world and in our country and in its schools. It knew that they were subject at the time to extremely harsh criminal laws. However, such people basically were left alone so long as they were completely silent about their reality, basically ashamed about it, willing always to pretend that their reality was different from what it was, that they were straight, that they were heterosexual. This was the world of silence about anything that could make a gay child's reality open and understood by the child, fellow students and teachers, by themselves. That silence was the coin in which they were paying a fee for being left alone, for avoiding causing skin curling to those who were heterosexual and didn't like to be reminded of the minority who were not. It has to be said quite bluntly to our Prime Minister that from national leaders, wise leadership is expected. Such leadership must be based eventually on scientific truth and rational understanding. To be unaware of gay conversion therapy and of the victims it has caused throughout the world is simply not good enough. Certainly, it cannot last long as an excuse for not thinking about the issue. To forbid any reference in a school to respecting sexual and other minorities may be acceptable in Baptist schools in Sydney, although I doubt it. I was raised in the Protestant tradition of Christianity as a Sydney Anglican. I adhere to that tradition, although not to all of the biblical literalism that it sometimes teaches. The essential message of all religions that I know is love for one another. That is why I welcome Prime Minister Morrison's identification with that message of love as the badge of his political program. But the jury is still out on whether he does really love LGBTIQ citizens or simply knows that they exist and tolerates them because he has no choice, and so long as they remain very silent. If the Prime Minister's daughter's school ignores the reality that some of their students, over time and inevitably, will be LGBTIQ, they are failing in their pastoral duty to all the students who come into their care. That should not happen to schools in Australia. It should certainly not happen to schools that are in receipt of federal funding. With that funding, from taxpayers of all religions and of no religion should come an irreducible commitment to every child in the care of such schools, whether public, private or religious. That means care for every child and education in values that the existence of Indigenous, racial, sexuality, identity, different religions and other elements in the school's students' lives entail. To demonise all education programs in Australia's schools that teach Australian school children of the realities of human diversity is not only bad science, it's bad for our community. It is isolating and destructive of children in the minorities concerned. And, I presume to say, it also happens to be contrary to spiritual and religious values, at least as I understand them. There will be no going back to the dark closet of self-denial, silence and shame for LGBTIQ school children in this country. The liberation is achieved by the light of education about diversity and basic kindness to one another as human beings and as citizens. That includes young human beings and young citizens. No law on religious freedom should be accepted in Australia that allows people on the basis of their religion to isolate, denigrate and humiliate minorities, whether those minorities are Indigenous, racial, gender-based, religious, disabled or gay Australians. And if that means a bit of skin curling for certain religious Australians who have not given enough thought to these issues, well, so be it. The thinking, although belated, will be quite good for them. It will be especially expected of them if they hold positions of public leadership and power in trust for the people of this country, because that means in trust for all the people of this country and certainly all the children of this country, including LGBTIQ children. There are many other issues caught up in this debate that lie far beyond the schoolroom. These include the extent to which religious citizens, on the basis of their faith, should be exempted from anti-discrimination laws that forbid words and conduct in defined circumstances that discriminate against people on the basis of Indigenous status, race, gender, disability, sexual orientation, or gender identity. In the United States of America, this subject too has been submitted to legal analysis. One such case involved, as you have undoubtedly heard, a Colorado baker who refused to make a wedding cake for a same-sex couple. The couple objected to his action and alleged serious discrimination contrary to the law of Colorado. In a divided decision of the United States Supreme Court in June of this year, Justice Kennedy, for the majority, came down on the side of the baker. However, this was not a decision of far-reaching principle that the proponents of religious freedoms had hoped for. The case actually went off on the footing that the decision makers in Colorado had not given the baker accused of discrimination a fair hearing of his asserted reasons for objecting to baking the cake. Just as lay people were entitled to dignified treatment and not to be humiliated by a baker refusing to take their cake order, religious bakers were entitled to due process and an opportunity to explain themselves to the state body having the power over complaints of anti-discrimination default in Colorado. This, it was held, was what free expression required. This sounds reasonably sensible, or at least an arguable viewpoint, but it leaves the general principle of the ambit of religious freedom still to be determined in the future in the United States. The right to hold and practice, or not to hold and practice religious beliefs, is common to all statements of fundamental human rights. However, nowhere in civil law or principle is it made an absolute right. In any statement of universal rights, religious freedoms must be balanced against the enjoyment of other competing rights, many of which coalesce in the right declared in the very first article of Eleanor Roosevelt's Universal Declaration of Human Rights. That first article says, "All persons are born free and equal in dignity and rights." All persons include LGBTIQ persons. It certainly includes all LGBTIQ school children. Where the exercise of one person of their religious beliefs diminishes or interferes in the dignity and human rights of another person, the competing rights of those other persons must be reconciled and adjusted in a principled way. As one sage put it, "The right to swing my arm finishes when my fist comes into contact with your chin." There are many exceptions already in place for religious bodies in Australia under current anti-discrimination law. Those exceptions apply in Australia by the Federal Sex Discrimination Act 1984. They allow religious bodies to discriminate on the basis of sexual orientation where it is, quote, necessary to avoid injury to religious susceptibilities or adherence to their religion. In the matter of performance of marriage ceremonies, for example, of same-sex couples, it has not been a feature of exemptions generally to permit publicly authorised marriage celebrants to refuse to conduct such ceremonies. Generally speaking, those who serve the Crown, the state, or the public at large just have to perform their duties or resign the public office. An exception for priests, ministers of religion, and other religious office holders is common and has long applied in Australia under the Marriage Act. I didn't hear anyone in the recent debate arguing that this exemption should be dissolved. Australia did add another exception in 2017 for private civil celebrants who opted into the new register of religious celebrants. They might refuse to conduct same-sex marriage ceremonies. However, this was to be a closed category. Civil celebrants appointed after 2017 were not to be entitled to refuse to conduct same-sex marriages on the grounds of their religion. Most such civil celebrants were only too glad to gain the extra business. These have been hard times for marriage. Many heterosexuals haven't been bothered getting married. The influence of new enthusiastic gay couples has been an unexpected boost that most civil celebrants have been only too glad to welcome. Good for business, good for society. The working out of applicable legislation has varied amongst the 29 countries that have now enacted same-sex marriage, and there isn't time in this address for me to go through all the exceptions and what they provide. There are many other issues affecting LGBTIQ people that have consequences for future legal regulation in Australia. A number of them are referred to directly and indirectly in the annual report of the Australian Research Centre in Sex, Health and Society at La Trobe University. I've been named a distinguished ambassador of that centre, and ambassador is a rank that I have always coveted. It's enough here to mention some of the topics that have been raised in the work of the scholars at that centre. Some of them are no doubt replicated in the work of the Human Rights Centre at Curtin University, and they concern such matters as sexual conduct and expression, whether heterosexual or LGBTIQ, and how it should be defined, how the language and definition of criminal offences should be re-expressed, how the expungement of past criminal offences and of convictions entered many years ago against LGBTIQ people for adult private consensual conduct, laws relating to the amendment of birth certificates, marriage certificates, and other public registries require attention. Provisions to govern access of family members, defining that term widely, in times of grave illness and disability require revision. So may a revision of taxation legislation be required, allowing exemptions for religious bodies engaged in what are substantially commercial activities. Family rejection, multicultural isolation, sporting facilities and other institutions with special challenges also need attention, and a lot of these issues were discussed earlier today in the magnificent conference that was organised here at Curtin University. Amongst the most serious problems are those that arise in the field of transgender citizens, and in particular transgender children seeking to transition into an identity other than that which they were assigned at their birth. Theirs, I believe, is the most challenging journey of them all. In my experience, L and G and even B rarely meet or mix with T persons. They may never have met them, and they may feel no kindred sympathy for them. And there is a lot of work to be done in education here for all of us, including LGBTIQ. Looking back on the great changes that have occurred in my lifetime on LGBTIQ rights, they make us optimistic, but also impatient to complete the changes. And those changes are not only required in Australia, the need extends far beyond Australia's shores. Certainly, they include the treatment of sexual minorities who flee cruelty and oppression in other countries, but end up in cruelty that we have ourselves specially devised for them in our detention camps. There, we Australians practice long-term detention, which we have outsourced or warehoused to facilities for asylum seekers that we have established in Nauru and Manus Island. Some of these persons are seeking asylum in Australia on the grounds of a well-founded fear of persecution on the basis of their sexual orientation and gender identity. And we are legally required by international law and morally required by kindness to one another as a nation to process and determine such claims for ourselves and not to outsource them to another nation to perform for us. Every now and again, there are moments of celebration. Above all, the recent decision of the Supreme Court of India, while striking down the British criminal laws against gays and declaring, in the words of one of the judges, that an apology was owed to the LGBTIQ citizens of India and their families, can be contrasted with what other countries are doing in respect of gays, compelling them to live a life full of fear and reprisal and persecution. What a powerful riposte for the ignominy and ostracism that the decision of the Supreme Court of India was in striking down as constitutionally invalid under the Indian Constitution, the Indian Penal Code section 377 that criminalised gay people in India. At a stroke, millions of people had a great burden lifted from their shoulders. Whether institutionalised disgust and contempt will be lifted, or whether blood curling of the kind that has been felt by our Prime Minister will delay that process, is the question that is before us tonight. The answer to that question really depends on all of us, and it's not only or even mainly a struggle for us in Australia. The journey continues. Scholars, politicians, allies and LGBTIQ citizens are all involved. Eventually, our blood will curl indeed when we look back on these present times and times earlier and think of how we treated LGBTIQ citizens and LGBTIQ human beings, and especially how we have treated children and the weak and the vulnerable, and of how long it took us to realise how wrong the old ways were, and how our blood was curling for so very long for quite the wrong reasons. We need a healthy potion to cure this phenomenon of blood curling. That potion is freely available at Curtin University and was in evidence all day today at the conference that was held here. It's a potion derived when the lemon of public policy is given a further squeeze. Then truth and rationality will present for all the Australian people in need of love. Not superficial or selective love, love for all persons who have been born free and equal in dignity and rights, just as Eleanor Roosevelt declared in the Universal Declaration of Human Rights, which was adopted 70 years ago with Dr. H.V. Evatt of Australia as the President of the General Assembly in the chair. All persons are born free and equal in dignity and rights. What wonderful words they are. They speak to Indigenous people, they speak to women, they speak to people of different races and different cultures, they speak to people with disabilities, and they certainly speak to people who are members of the sexual minorities by reason of their sexual orientation and gender identity, and particularly they speak to the children who are in that category.